Hello, and thank you all very much for joining us. For those of you who don't know me, I'm Richard Pettit, one of the partners in the Burgess Salmon pensions team. I should start off with a little bit of housekeeping. I'm sure many of you will have used WebEx before, but for those of you who haven't, if you go to the top right-hand corner of your screen, you'll find a layout icon where you can change your view. For this seminar, we'd recommend you use the grid layout, and I'll explain why in a minute, and probably to turn off there's an option to hide participants with video off as well, which I think should work. This webinar is being recorded, and the recording will be available from our website in due course. The idea for holding this particular webinar occurred to me just before Christmas, and I was thinking back over how 2020 had gone for all of us. It reminded me of what I think is actually an apocryphal curse: may you live in interesting times. I can't imagine, I can't imagine there's anyone watching this webinar who doesn't feel that they suffered under that curse last year. Of course, with COVID-19, what we first think of is the terrible human cost across the globe, and that's what's at the forefront of all our minds. But we're all also aware of the huge economic impact and how that's played out into specific areas like pensions. Personally, of course, I would say that those of us who work in pensions were already condemned to live in interesting times well before COVID-19 hit, with seemingly endless new legislation, guidance and other challenges. And that brings me to the aim of this particular webinar. My personal view is that anyone with responsibility for pensions, whether they're a trustee, a pensions manager, company management, or an advisor, face a bewildering range of issues. It's possible to see each one of those as being of vital importance and requiring urgent attention. Every day there's an article in the pensions press or even a webinar detailing the next big thing that you need to focus on. That makes it very difficult to know what you actually should focus on and where to start. So today's session aims to do exactly what it says on the tin, to help trustees, company management and advisors to plan and prioritise what to focus on for 2021. To do that, I'm joined by a panel from across our team. We're each going to give their view on a key issue or issue that should be prioritised for 2021. We have Alice Honeywell, a partner in our pensions team, Chris Brown, a senior member of our pensions team with particular experience in regulatory work, and Suzanne Padmore, who's one of the partners heading our pensions disputes work. We're going to deliberately take a less formal style, each person speaking for short sections, and I may interrupt people as they go, although I haven't fully warned them about that, so we'll see whether I choose to do that or not. I'm also particularly going to be challenging each one of the speakers to give 1, 2 or maybe 3 takeaways of what actually needs to be done this year rather than what can wait. What we're not going to do today is do a deep dive in any of those topics. We'll just be giving an overview to help with planning and prioritising, coming up with key action points. So for that reason, we won't work through slides. You'll just see us on the screen. As I mentioned at the start, it's probably best to use the icon in the top right-hand corner, go to grid view, so you can see all of us, and you can hide participants with video off. Unfortunately, I don't think there's an option just to hide Richard Pettit. I'm sure some of you might want to try and find that as you go through, but I'll leave it all to your discretion. So although we won't be showing slides as we go through, we will have summary slides at the end with key takeaway points. I'll flash those up and briefly talk through those, but also they'll be circulated to all of you by email. I know all of you will be busy, so we'll have a hard cut-off ending the seminar at 10:45. If you have questions as we go through, then please do use the Q&A function to type them in and submit them. You should find that on the bottom right-hand corner of your screen. You might need to press the 3 dots to expand it. There's a little arrow next to Q&A. If you type any questions you've got in there, address them to all speakers. As I say, there'll be time at the end and we'll try and get through all the questions. For any questions we don't get to deal with during the webinar, we'll follow up with you by email, so you will get an answer from us. So what are these priorities for 2021? Personally, I'd say they fall into 2 broad categories. The first of those which hit the pensions headlines and everyone talks about, even if they're not necessarily taking all the steps they should. These include things like the changes to the scheme funding regime, GMP equalisation, environmental, social and governance factors, ESG, and the regulator's new powers under the Pension Schemes Act. The second category, those which aren't necessarily seen as top priorities. That's either because people have lost interest in them and the headlines have died away, or because frankly they weren't, people weren't that interested in the first place. In that kind of category, I'd place things like pension scams and transfers, perennial issue of Brexit, cybersecurity, and getting back to basic good governance. So the first of those categories, headline issues, over to Chris first to talk us through the proposed changes to the scheme funding regime and focusing on key steps that trustees and employers need to take.
Yeah, thanks, Richard, and good morning, everyone. I think it's fair to say that the state of funding of defined benefit pension schemes has been in a state of flux for a few years. It was 3 years ago now, back in 2018. And Richard, I remember you and I doing a talk about it at the time that the government's white paper on protecting DB schemes was published. and the changes have been slow coming. But we're able to speak with a bit more clarity now. So the Pension Schemes Act has not yet, but is just about to be passed. Final stage is it receiving royal assent. And on funding, that will be introducing a new long-term funding and investment strategy that trustees and employers will need to agree as part of their valuations. So when the Act finally receives royal assent, will that be enforced straight away? Well, the answer is no. We'll be waiting on secondary legislation to tell us the detail of what needs to be in that strategy, and also what needs to be in the statements that trustees will need to send to the regulator about that strategy. But we've also had the regulator's interim response to its first consultation on the new funding code. And as many listeners will know, the first consultation proposed 8 key funding principles, including a twin track approach to valuations, the fast track and the bespoke track. And the interim response is quite interesting because it's not just a holding response. Sure, it says that the second consultation will be expected in the second half of 2021, but it also recognises that a number of the responses to the first consultation contained good challenges and ideas, and it recognised that the regulator will evolve its thinking. So I think the language of the interim response is quite interesting. What that means is we might see answers in 2021, and hopefully we will when the second consultation comes out later in the year, to questions like, will the fast track lead to levelling down? Will it be more expensive? Is bespoke truly bespoke, or will it be benchmarked against the fast track? So answers still to come, but I think we have had some comfort recently. So the government in the House of Lords debates, the final House of Lords debates, confirm that open schemes that are not maturing and have a strong employer covenant should not be forced into an inappropriate de-risking journey. So some comfort there for open schemes. And the interim response also gave us comfort that the fast track guidelines will take account of COVID. So what does all that mean for trustees and employers right now? Well, when the new regime was proposed, Richard, you and I were speaking about it, the sense in the industry was that everything was coming fairly quickly, and that parties should have regard to the direction of travel and particularly the long-term objective. And of course, proper flight planning and de-risking for a scheme in the longer term is the correct thing to do. But the continued delay in implementation, particularly with the continued impact of the pandemic, perhaps means that there's less or there's a reduced pressure to comply ahead of time. So I think if you are if you're not in a current valuation cycle, then keep a watching brief on the changes. If you haven't already, perhaps consider how your schemes approach stacks up to what we know of the fast track. If you are in a current valuation process, then I think there will be a change in emphasis to ongoing valuations at the moment, with a trend towards taking into account the direction of travel. And of course, that's sensible future-proofing of any funding strategy. But also, we're in this unique current dynamic. Employers will no doubt be looking to preserve cash, and no doubt be arguing that the changes will not come into force until start of 2022 at the earliest, and that current valuation should take place under the current regime. So in terms of takeaways, I think I wanted to leave you with a basic one, which is sort of back to basics. We can't stress enough the importance of negotiating, of recording negotiations, of recording decisions, and the rationale for those decisions, so to protect trustees and employers. But I guess the main thing that sort of springs to mind at the moment is there's been lots of news about the funding regime and the Pension Schemes Act getting through Parliament and the progress of the consultation. But is anything changing right now on the funding regime overnight? Not really.
Perfect, thank you, Chris. Those really useful takeaways, and I think reassuring. And as you know, I like the sort of back to basics, and my favourite mantra is audit trail, audit trail, audit trail, things like negotiation. So that's brilliant. Thank you. I was going to hand over to Alice, which is probably the biggest challenge of the day, to cover GMP equalisation snappily in 5 minutes, not naturally a snappy topic, and to give easy key takeaways for everyone. So over to you to pick up that challenge, Alice.
Thanks, and good morning, everybody. I will try and resist the temptation to talk about GMP equalisation all morning, partly because either you're in the fortunate position of not having a pension scheme dealing with GMPs, in which case you can sit here smugly, or otherwise it's something that you do have to deal with and you already probably know a fair bit about. But I suppose just to summarise where we are, there have been a lot of developments over the last year, including kind of important pieces of guidance from industry bodies and particularly importantly HMRC. Now, we all know that that hasn't gone necessarily as far as we might hope. For example, we don't yet have anything from HMRC on conversion, and we still don't know whether or not there will be. As well, the back end of last year, again, many of you will be aware, there was another important hearing and decision in the Lloyds case, and this one related to duties in relation to transfers out. The other thing that's been going on is there has been a lot of activity. Now, while many schemes are still in waiting mode, some have a burning platform, mainly schemes in wind-up, where they have had to get on with it, grasp the nettle, and go ahead and do GMP equalisation. And this is producing a good deal of experience. It's showing where some of the knotty problems come up. And so there is now a good body of experience and expertise in order to help employers and trustees through this process. But sitting here today, we still know that there might be more to come from regulators and industry bodies and so on. What should employers and trustees be thinking about? Well, my first key action is that if you haven't already, it is time now to be looking at equalising transfers out. Following that second Lloyds judgment I referred to, it's absolutely clear that that needs to be done, and so that's something certainly to be looking at. The second action I would be doing at the moment, if you haven't already, is reviewing data. Initially, this may be at a fairly high level to understand what the scale of your issue is here, where the gaps are, how sensitive to those gaps the calculations are going to be, how far do you need to dig in, and where can you use assumptions. Now, you may have already done quite a bit of that for your main bulk of existing members, but there might be a new element to that you need to do now following the Lloyds case to look back at historic transfers out. And at least some scale of this is going to potentially be needed fairly soon for accounts purposes. So there will already be companies who've been scampering to get this done for December year ends, and that will continue for other year ends during the year. But we're also expecting to see schemes need to put some figures in their accounts for when they come to the next year end, which obviously will depend on your specific year. So there will be actions to take there. The third thing I would say is a project plan. It's very clear that these processes in most cases take quite a significant amount of time. There will be a number of decisions over a period. There will be lots of times where you've got somebody going away, doing calculations, undertaking further investigations, and that all takes resource. And so it's really important to, if you haven't already, getting a project plan in place as to how and when you're going to undertake this project. And how importantly you want to run it. Is this going to be something the employer leads? Is it something the trustees are going to lead, and with occasional checking in with the employer? Is it something where you're going to have a subcommittee, a working group that's really driving it, or is it going to be something that's more or less left to the consultants checking in occasionally with the trustees? So it's really important to think about how you're going to go about this, and then as you go through that process, to come up with a straw man methodology and to really test that to see if it's going to work, see if there's any tweaks that need to be made for particular categories of members. And then, yeah, I think you'll find this is a theme of our talk today. The real key message to leave you with is around audit trail. As I've mentioned, it's going to be quite a long process, and there will be a series of decisions over the period. And what's absolutely clear is when you come to the end of your project, not only for the trustees' benefit, but also in the case of any future risk transfer to the insurer, for example, at the end of the life of the scheme, you're going to need to be able to evidence how and why you did GMP equalisation. And whilst you could, 2 years in at the end of the project, gather that all together into one document, it'll be far easier to do it as you go along. So that's a key thing to be thinking about as you go. Just before I leave this topic, a brief word on what is there still to come. Well, we know that the PASA industry group is planning to release further guidance on some of the tax issues and also on the Lloyd's 2K, so we'll watch with interest for those. There's also some hints that the DWP might still be considering whether to amend the conversion legislation. As yet, that's unclear, and particularly as to timeline, but again, something to be worth watching out for. And as I mentioned as well, it's possible but unknown at this stage whether HMRC is going to release any more guidance specifically in relation to the tax issues surrounding conversion.
Brilliant. Thank you, Alice. That's really useful. And yeah, particularly focusing on the audit trail and obviously keep those biggest key actions if you haven't already closing transfers out, otherwise getting ready. So thanks for rising to that challenge. As I said, GMP equalisation often a headline issue, but not quite as headline grabbing perhaps as the occasional suggestion in the pensions press that trustees, directors of employers and even advisors might end up being sent to prison by the pensions regulator for probably things that are completely above board. So over to Chris with the perhaps even bigger challenge to reassure us about why the forthcoming Pension Schemes Act isn't going to cause that problem, or certainly what we can do immediately and need to do to minimise that risk.
Yeah, thanks, Richard. Well, I'll do my best to reassure people. There are a number of unanswered questions still out there, I guess. On the regulatory powers and criminal sanctions, I mean, these have been widely reported on, as you say, Richard, particularly the criminal sanctions, the two main ones being conduct that is avoidance of an employer debt and conduct that risks accrued benefits. And you might think, oh, well, none of this really applies to my scheme, does it? But I think what's been, quite widely reported is that these offences and also the new threshold test or tests for the regulator to use its anti-avoidance power to impose a notice requiring someone to contribute to a scheme, they're very widely drafted, and they could catch routine business activity like paying dividends, a refinancing, granting security, doing a business restructuring. But what I wanted to mention today is that we are seeing parties beginning to have regard to the changing powers and the strengthening of the regulator's powers, the criminal sanctions, and taking steps to seek to protect themselves. So, for example, Richard and I, we acted on a relatively routine flexible apportionment arrangement in summer of last year. So a flexible apportionment arrangement is where you transfer liabilities from one employer to another in a multi-employer scheme in order to let the first employer off the hook for pension liabilities and to separate it from its obligations to the scheme. And we were doing that in the context of a business transaction where our employer was being sold out of the group, and the buyer's lawyers insisted that their client and our employer sponsor and our client, the trustees, make a clearance application to the regulator for comfort that there was no material detriment to the scheme and the regulator wouldn't use its powers in relation to the flexible apportionment arrangement. And that was in a context where the trustees had received advice from a covenant advisor on the funding test. But we were seeing that sort of extra step. Alice, I think you have also seen something similar recently as well.
Yes, that's right. So on a flexible apportionment arrangement where we were acting trustee side, fairly small transaction actually, but as that kicked off before Christmas, one of the first things the company's lawyers said to us was we'll expect to be seeing the legal and actuarial covenant advice that the trustees receive, specifically with these new powers in mind of the regulator. Now, obviously, it's a quite separate question as to what the trustees might be willing to share, but it just shows the direction of travel in the way that you might expect to find advisors slightly changing the thought process around these sorts of matters.
Yeah, absolutely, and that's because there is a defence to the criminal offence that you have a reasonable excuse for acting in the way that you did, and also there is a defence to the regulator's ability to impose a contribution notice on you, which essentially is that you've considered the impact of your actions and decided there's no impact that meets the test for a contribution notice, or if there is, that you've mitigated it. Now, you might be listening to this and thinking, oh well, Chris, that's all well and good, but hasn't it been confirmed that this stuff isn't law yet and won't be law when the Pension Schemes Act is passed? And you'd be right. So Guy Opperman, the Pensions Minister, has confirmed that these powers will not come into force until the regulator has consulted on the criminal sanctions, and that when they do come into force, they won't have retrospective effect. But we think parties would be wise to have regard to these measures now, partly to show thinking ahead and compliance with a changing regime and sort of planning for the changing regime, partly because Mr. Opperman's statement is slightly inconsistent, internally inconsistent on the extent of retrospectivity, but also because past conduct can be a factor that goes to the reasonableness of the regulator using its powers. So when we do have these powers come into force, if the regulator looks at an act that happens in the future and decides to use its contribution notice power there, then when looking at whether it's reasonable to impose a contribution notice there, it can look back on past actions, things that are happening now, to decide reasonableness. So we think we'll see a greater need for advice and recording decisions, both trustees and employers, particularly on corporate transactions, because, of course, the other key change coming in the Pension Schemes Act is increased notification and disclosure obligations to the trustees and to the regulator. So one thing that could be worth considering putting on business plans for early 2021 is to consider training for trustee boards, for boards of directors and other key stakeholders, because pensions will need to be more of a priority than it has been on business transactions, but also on routine business activity. I guess the key takeaway, Richard, is to be aware of the changes coming and to consider the increased role of pensions on business activity.
Perfect, thank you, Chris. That's very useful. Finishing up on our headline points, I don't think I could talk about headline points without talking about ESG, environmental, social and governance factors, particularly given that our pensions minister, as Chris said, is Guy Opperman, set out managing climate risk as one of his key priorities for 2021. It's obvious that there's a huge push in government on climate change. It's part of the wider net zero agenda, perhaps tied in with the COP26 conference being hosted in Glasgow in November, I think. That said, there's a big question in my mind about how much of a priority taking significant action on this needs to be for trustees, given the limits on what trustees who invest through pooled funds, for example, can do. There's clearly a lot of willingness among trustee boards and a lot has already been done. There are also important compliance steps to take, things like implementation statements being made and monitoring the situation. And I would say that for most trustee boards, it's a case of making sure you tick the boxes on that and otherwise continuing as you have, getting ready and pushing investment managers where you can. The main takeaway would actually be to step back and think more widely than climate change in terms of investment, but also think about it in terms of impact on covenant. Where does your sponsor operate? Do you have a sponsor in the aviation industry? Obviously fairly hit by COVID at the moment, but also longer term by the impact of climate change. There are easy extreme examples. If you have a pension scheme that's sponsored by a company that runs a coal-fired power plant, the likelihood of that power plant being able to make money beyond the next 5 years is fairly limited. And the other key thing is just it's almost from a governance perspective to make sure don't miss the other two letters of ESG, the social and the governance factors, and considering those both in relation to investments and the likely future performance of investments, but also in relation to your covenant. So just limited key takeaways, I think, on that. That now takes us to our second category. I said, not headline issues. Probably a bit of a stretch to say that what I'm going to ask Suzanne to talk about, which is transfers and pension scams, isn't a headline issue. It certainly has been in the past, and it's an issue of vital importance. But over to you, Suzanne.
Thanks, Richard, and good morning, everyone. When we were discussing the webinar, we hoped that we'd have 200 of you joining us, and I've just checked the numbers, and we have exactly 200 of you online with us today. So thanks very much for joining us. I think the overarching objective of everything that we're talking about this morning is, I always think, to make sure that schemes are in a position to pay benefits to members when they fall due. a major risk of that not happening is the risk of the member themselves making a decision to take themselves out of the scheme rather than anything done or not done by trustees, employers or scheme advisors. And this is when a member decides to transfer their benefits out of the scheme, either in circumstances where that isn't a sensible financial decision for them in their own personal circumstances, or at the very worst, if they fall victim of a scam. And I think this, Richard, is, as you said, Richard, is an area where, like in a lot of pensions generally, where there is almost a bewildering amount of coverage in the pensions press and the wider press on this issue. It may have fallen slightly off the headlines because of, in particular, COVID, obviously, but it is an area, I think, where there is a lot of coverage where trustees can try to cut through the noise and focus their efforts on action that can really make a difference to protect members. The activity in the market comes from lots of different angles. For example, the FCA has been really active in the area of pension transfer advice for many years. And I think sometimes it's almost difficult to determine precisely at what stage their work has reached. The number of different angles is not surprising, as the issues of pension transfers and scams has touch points with many regulators and other public bodies. A clear example of this was last year in May. There was a guidance booklet produced called COVID-19 and My Pension, and that had contributions from the FCA, the pensions regulator, the pensions ombudsman, the Money Advice Service, the PPF and FSCS. So it's a good example of the industry showing how much support there is for pension savers and scheme members. But as I said, it can be slightly bewildering for pensions professionals, let alone members themselves. In terms of other specific ongoing activity, last year the Department for Work and Pensions launched an inquiry into pension scams on the 5-year anniversary of the pensions freedoms. The call for written evidence closed in September, but the oral evidence sessions are ongoing, including this week. And the outcome of that inquiry is certainly worth looking out for later this year. HMRC is very active, having deregistered over 700 schemes last year, which is an indication of the scale of the risk. And one of the most significant developments last year was the pensions regulator launching its pledge to combat pension scams. And this covers actions that trustees can do, and they can self-certify that they are acting in accordance with the pledge. And if you forgive me, Richard, for delving into a little bit of detail, these actions are to regularly warn members of the risk of scams, encouraging members requesting a transfer to call the Pensions Advisory Service for free advice, for trustees to learn the warning signs of a scam and best practice for transfers, and I'll return to that, take all appropriate due diligence measures and document pension transfer procedures. So that goes back to our theme in relation to documenting and having an audit trail of what processes and decisions are made, communicating concerns to members if high-risk transfers must be made, and reporting concerns to the authorities and communicating with the member. So I have read that transfer activity fell by 20% last year, so it might be that the activity in the market is having a good impact, and generally good news that some members are refraining or at least delaying transfer decisions in these uncertain times. But a figure I have also read is that on average victims of scams last year lost £91,000 each. So the issue is still clearly a real and material risk for members. And that risk currently remains in the context of members having a statutory right to transfer. And also we're operating in the environment created by the pensions freedoms, which are only 5 years old. So I think despite the DWP inquiry into pension scams, I think there's unlikely to be a significant shift away from members having options. And the trustees remain in a difficult position between identifying risks and taking action on those and the possibility of facing an insistent transferee. But looking forward, there is likely to be real development in this area in the Pension Schemes Act. As Chris said, it's still awaiting royal assent, but will become law very soon. And it sets out that regulations, so we will have to wait for secondary legislation, but regulations can be made which will impose conditions on the provisions relating to transfers under the Pension Schemes Act 1993. So, for example, the right to a transfer and the time limits imposed on trustees to carry out a transfer will not apply in certain circumstances. So the conditions that might be prescribed by regulations relate to checking the member's employment or place of residence and requiring the member to provide evidence of that, checking or advising the member to obtain information or guidance or advice, and similarly providing evidence to the trustees that they did take that information and guidance. So I think that's really good news, and the regulations will clearly be intended to provide additional protection for members against unsuitable transfers or scams. But in the meantime, trustees remain in the position where they have to manage risks, including that a member may transfer away anyway, even if the trustees don't think it's a sensible transfer. But I think there are specific things that schemes should be doing, and I certainly don't think that schemes can just wait until the regulations are in place, not least because the regulations will, in a sense, allow trustees to rely on the information they obtain, for example, through due diligence process. So the regulations won't in any way remove the best practice and the obligation on trustees to carry out those checks. So in terms of takeaway points, I think key actions are to consider member communications on transfers and scams now. So even if there were communications in a scheme last year, I think it would be a really good idea to make a decision early this year about when communications will be made again. The content on those will depend on what was said before and how it aligns with any update on the regulations. And I think probably the key step will be for all schemes to consider the pensions regulator's pledge to combat pension scams. This covers the things I mentioned earlier, but it also recommends for trustees to follow the Pension Scam Industry Group's Code of Good Practice. And I think the real action here is for trustees to make sure that their arrangements are in line with that code. In client discussions with trustees, there's clearly a lot of confidence that administrators' procedures are adopting best practice, but it's not always clear that there is an awareness of the precise steps taken upon a transfer request and the extent to which they're in line with the code. So I think a good action, a positive action for trustees would be to ask administrators to present on this to a trustee meeting and to get that presentation on an agenda now. And finally, to keep abreast of relevant regulations under the Pension Schemes Act later this year. And I think look to your legal advisors to provide an update on the specific provisions in the regulations when they come out. So those are my 3 takeaway points, Richard.
Perfect. Thanks, Suzanne. I do forgive you for delving into the detail of that, because I think this is one of the most important things for trustees and indeed for employers. It's a case of stepping back, and as you said, what's the most important thing for a pension scheme to do is to pay benefits to members. If there's a slight issue with the correct amount of the GMP equalisation, for example, or issues with funding, is not as immediate catastrophic impact for members if they lose all or most of their savings through a scam. So really important stuff. Thank you. Alice, as I tasked you looking at GMP equalisation as a more difficult topic, I thought I'd hand to you and give you the nice topic of Brexit to talk about.
Yes, I get all the fun ones, don't I? So Brexit, I think we all know about that. It is at least good news to have some certainty in the form of the deal that was agreed at the end of last year. So what are the key actions to take now? Well, you will have already been, no doubt, monitoring the impact on your investments and on employer covenant ever since the referendum, and along with the impact of COVID-19. That's something that should obviously be continued during the course of this year, and particularly in sectors where the new deal, which only has just beginning to be implemented now is particularly important, with exports and so on. That'll be a key area to understand how it's actually playing out and what impact that has on the covenant. If you have an overseas sponsor in the EU, EEA, then it is important to think about whether Brexit has had an impact there, any legal niceties that might arise. A particular example can be around PPF eligibility. So that's, if you're in that position, you may have been waiting to find out what the deal was going to be, and if you haven't already, it is certainly worth taking advice on that particular point. Equally, if you have UK-based employers, but you have an overseas parent who's provided some sort of guarantee or other contingent asset that you're relying on, again, it's worth double checking whether there's any impacts there or any tweaks you might want to make to the agreements in place to affect Brexit. So recommend taking early advice on that. Another area where we've seen quite a bit of interesting queries over the last few weeks has been people working overseas. So this is obviously wider than just the EU, but I suppose it's particularly something that's changed post-Brexit with EU workers. And often people have gone temporarily for COVID reasons and now potentially looking to make it more permanent. It does create a whole host of labour law and tax issues, so it's certainly not something straightforward, but I suppose just to flag that there are also potential pensions issues, so something to think about if you've got employees or members who are asking to make those sorts of arrangements. And finally, data protection, that's a bit less urgent, which is good news, I suppose, in that there is a 4-month window which might be extended to 6 months in terms of the flow of information from the EU to the UK. Currently, at the moment, it's okay and intended to continue for transfers from the UK to the EU and EEA. So that's something to be monitoring to see whether that any further actions are going to be taken. So one to keep on the agenda in the background. And whilst I touch on data protection, I can't not mention cyber risk as well, because again, this is like the scams issue, something that is potentially catastrophic for members and schemes. Clearly, cyber risk extends to the personal data that's held on all of the employees and members in pension schemes, but also can directly affect the safety and security of assets held by the pension scheme. We are often reminded that to think about cyber risk in terms of when and not if, and I think that's a very good way to think about it. Different pension schemes and employers have thought about this and done more or less preparation. I think we're all aware that this is a developing area, and so it's, even if you've done something, it is always worth keeping it high on the agenda and keeping it under review. But certainly if you haven't done anything yet, I would recommend starting to think about an incident response plan so that you are prepared for that when and not if scenario, and thinking about what contractual protections you have in place with your service providers on whom you're likely to rely in the circumstances. Do you have clarity on where responsibility lies, and also do you have other obligations around collaboration should an incident arise?
Brilliant, thank you, Alice. And a bit like pension transfers and scams, I suppose in my view it's one of the top priorities. Cyber particularly is one of the top priorities for trustees, because it's thinking about what could that very significant impact be on a member or members compared to some of the other legal issues. If member data and member financial information is leaked, for example, because of a cyber attack or an email that's gone astray. So really important to focus on that. Just going through those topics to a close, I was going to cover governance and back to basics. I'll do that briefly because I know we want 5 minutes for questions at the end. It's really doing what it says on the tin. I mean, the regulator is focusing on governance. It's a new consolidated code, bringing 15 of its DB codes down to 1, due out for consultation later this year, and we'll see how much of a change, whether there's simplification for trustees to follow that or not, whether it's just pushing a lot more of the detail out on trustees to work out. But in terms of back to basics, what I'd always say, apart from audit trail, as you've seen here, is just it's important for trustees and employers to really understand the specifics of their scheme. What powers do you have? Your contribution rule. What powers do trustees have in the event of a serious scenario coming up? If you have a guarantee in place, what does it say? What benefits does it actually cover? When can it be released? Do you have an information sharing framework in place to share covenant information? And one that's often overlooked slightly is getting conflicts and potential conflicts sorted early, making sure that those are resolved. You maybe have a subcommittee on standby so that if an issue suddenly comes up, you don't waste time getting that sorted and working out who's going to deal with things. So Andrew, if you're happy to put up the summary slide now, I'll just flash that slide up on the screen. I think you saw it briefly earlier. It's the takeaway points, and I said we will email that round to all of you afterwards, so as a way of notes for you all. Clearly there's some points we haven't touched on at all today, which will have their own series of webinars, things like DB consolidators, buy-ins, and lots of developments in the market, and we will be more webinars from us in due course, but this is what we thought were the key priorities for trustees, employers and advisors over 2021. So I think that we do now have 5 minutes for questions. As I've been summing up, Suzanne has been quickly skimming through to pick the first question, I think.
Yes, yeah, I've got one here for Chris, I think. It says, are you saying to apply for clearance on every business transaction? Will you be sitting on the fence, and is that just extra fees for you?
Yeah, thanks, Suzanne. No, I'm not saying that at all. Not suggesting, by mentioning clearance, not suggesting that there should be a clearance application on every business transaction or on every business decision. It will very much depend on the circumstances. I think what a clearance application does give parties is certainty of comfort, of protection from the regulator's powers. And I think that's protection from the regulator's powers and sanctions, but also protection from the time, cost and expense of having to engage and respond to a regulatory investigation, which can not be inconsiderable. So mention it for certainty in that respect. But I think a key protection will be, as we've said, back to basics, documenting decisions, audit trail, in order to be able to show you've considered a pension scheme and the reasonableness of your decision making.
Thank you, Chris. I should say that probably 90% of the questions we've had come in have been about GMP equalisation, so I don't know whether that's because you handled it particularly in a particularly exciting way, Alice, or not. Open to you, Alice. I don't know if there were any particular questions that you thought most pertinent, otherwise I can pick one for you.
That's okay, I'll pick. There's been a number of questions relating to schemes that have wound up and what to do about those, particularly going back on transfers out and I suppose other benefits that have been secured. And that certainly is a sort of knotty question, but I suppose the starting point for those schemes is that they have been wound up, the assets have been distributed. There isn't a fund there with which to do anything with. So if you have a particularly concerned employer, I suppose they could start an investigation and look at finding a way to make good on some of those liabilities that are now found to have been underpaid or undersecured. But really, I think the priority is going to have to be those schemes that are currently ongoing or currently in the process of winding up. And it may be that there are members from former schemes who do come back, and then trustees will be looking to their insurance that they secured at the time of wind up, or any indemnities they secured, or to any other arrangements they put in place at the time. But the nub of it for wound up schemes is that there aren't trust assets left there with which to satisfy the claims.
Perfect, thank you. We've got just time for one brief one to Chris to answer in a couple of words, if you don't mind, which is for trustees, what's the position if the employer is not going to agree to a long-term strategy for de-risking in the new regime? Can trustees proceed anyway? And I suppose, is it really the answer, Chris, that in short, there's not much change from the current position?
Yeah, I think that's right. So the basic position is that employer and trustees will need to agree it as part of the evaluation, and if you can't do that, then you can't agree the valuation, and you go through those processes with a regulator. I guess the position is slightly different. So the question asks, once the new regime is in force, position might be slightly different before the regime comes into force.
Yeah, I suppose as post the regime, you have more chance if you get to failure to agree that you get the regulator's involvement, and we'll see things develop in practice. Excellent. Well, thank you again all very much for joining us. Those questions, and there are quite a few on GMP at least that we haven't had a chance to get to, we will pick up with everyone everyone who's asked a question by email. If you do have any other questions, then please feel free to email any of us. So all it remains me to say thank you very much for joining us. I'm required to say please fill in our feedback survey, which should pop up as you leave this. Thank you, and hope to see you all again, perhaps in person soon. Thank you.
Bye.